Today. This webinar is sponsored by the Resource Center on Domestic Violence, Child Protection, and Custody. And our topic today is overrepresentation of marginalized communities in child welfare. Good. We're going to start with the poll question, if you wouldn't mind taking a minute to respond.
All right, thank you all for answering the poll and answering your others in the chat box.
All right, my name is Judge Karen Howze. I'm the judge in residence here at the National Council of Juvenile and Family Court Judges. It's a pleasure to be here with you today. This webinar, we hope, as a result, you will be able to explore the history of overrepresentation of certain communities in child welfare and its relationship in cases involving domestic violence. We're also hoping that you'll understand the impact of overrepresentation on outcomes for children, and you'll be able to explore opportunities to decrease the impact of overrepresentation upon children and families. So let's get started. I'd like to start with a quote from Robert Hill, who actually was one of the first folks who delved into the issue of disproportionality, particularly in child welfare. This is a quote from Dr. Hill. Relationships between race, ethnicity, and disproportionate representation and treatment are complex. That is quite an understatement. So let's look at some of the facts regarding overrepresentation. These are the facts over time across the country. Overrepresentation of children of color in the child welfare system was first noted by researchers in 1972. The issue had already been under discussion in the juvenile justice arena for a few years before that. There have been 3 national incident studies of child abuse and neglect conducted by the U.S. Department of Health and Human Services from 1980 to 1996. Those studies found no differences in the incidence of child abuse and neglect according to racial group. So just because you're Black, Hispanic, or Native does not mean you're more likely to maltreat your children. Now, there are 5 major studies in 4 states between 1990 and 1999. These studies reveal that white children are 4 times more likely than African American children to be reunited with their families after removal. These studies also show that white children are reunited more quickly than children of color. Now, there are 2 realities on the issue of overrepresentation. In a 2016 issue brief issued by the U.S. Department of Health and Human Services, disproportionality was defined as the underrepresentation or overrepresentation of a racial or ethnic group compared to its percentage in the total population. Disproportionality or disparity in treatment is another aspect of the overrepresentation issue. And disparity is defined as the unequal treatment provided to children of color as compared to outcomes for another racial or ethnic group. So not only is there the issue of removal, but there also is the issue of how quickly do the children of color move through the system to permanency. The research has shown that of those children requiring substitute care, 56% of African American children were placed in foster care, while 72% of white children receive in-home services. This is the results of an Annie E. Casey Foundation study in 1999 and also a HHS report. The U.S. Children's Bureau in 1997 found that African American children remain in foster care for longer periods of time. This is dealing with the issue of disparity. Other research showed that the race of a child has been identified across professions as a factor in disproportionality. An example, and this is where the allied health fields come into play in this scenario. A 2002 study of children under 3 who had pediatric fractures found that children of color, 53%, were more than twice as likely as Caucasian children, 23%, to be reported for suspected physical abuse. Rather, the white children were classified as having accidents. Over the decades, research has also shown that families from various racial and ethnic groups are no more likely than any other group to engage in child maltreatment or require system intervention. Research has also shown that families from poor communities are more frequently involved with intervention systems. A few examples that you might identify with are, if you live in public housing, the walls may be thinner, so people may hear things differently than if you lived in a brick structure with a yard between houses. There also is the frequency of law enforcement intervention in communities where there may be a high incidence of violence or other issues related to crime. So then those families are more likely to come into the realm of the views of the system. Now, DV and child welfare. There is no data that shows how many child welfare cases also involve domestic violence. Just as DV is hidden in many communities, whether it's related to children or elders, it is estimated that as many as 50% of abuse and neglect cases have some element of domestic violence, physical, emotional abuse of a parent, even if abuse was not the reason the child welfare system became involved. So we have to always look at that as an element as we're examining these cases. Let's take a look at this chart. This is these are the numbers. In September of 2015, U.S. Census data and HHS APCAR show that there were 427,145 children in the child welfare system in the United States. This chart shows the percentages of varying ethnic or racial groups in the population. If you take a look at African American, the second line, totals 24%, even though only 13.3% of these children are represented in the total U.S. population. Hispanic children, 21%, though their percentage in the total population, children's population, is 17.8%. Now, non-Hispanic whites, percent in the system, 45.98%, and they are 22.8% of the total population. We also can look at adoption records from public agencies. Again, this is also from the HHS APCAR figures. African Americans adopted with public agency involvement in 2015, 18% in the system. Hispanics, 22%. Native Americans, 2%. Non-Hispanic white, 48% in the system. Now, consider who we talk about as marginalized communities. You know, all of this research that we just discussed that goes back to 72, it was primarily focused on black children versus white children, and then Hispanic children were also added to the mix. But today, when we look at our society, who are the children that we are talking about as part of marginalized communities? Of course, children of color are the main focus, but we also have people and children with disabilities. How about poor people, which is pretty much the profile of folks who are engaged with the child welfare system, and that has been documented. What about rural versus city folk? And please feel free to type into the chat area, what about any other groups that should be thrown into this discussion? All right, so let's look now at the next part of our exploration here today. The law requires the balancing in child welfare of the interests of the parties based solely on the facts presented as the system works with children and families to ensure safety, permanency, and well-being. At the same time, our society is filled with differences that often affect our interpretation of the facts that are central to the application of the rule of law in abuse and neglect cases. As law enforcement, medical professionals, social workers, attorneys, and judges work to help eliminate risk to children while providing assistance to strengthen family resilience, it is clear that every child is unique, each parent is unique, and we extend that out, each family is unique. Part of the issue that has been under discussion for decades regarding disproportionality and disparity is the fact that uniqueness has not been our focus often. We have used cookie-cutter solutions to try to fulfill our responsibilities when we are dealing with child maltreatment. At the same time, our society is filled with differences that often affect the interpretation of the facts and the interpretation of the circumstances of children and their families, even though those interpretations have become central to the application of the law. So let's look at our history a bit. This next series of slides walks through the history of U.S. child protection laws. We start with 1974 with the Child Abuse Prevention and Treatment Act, 1978 Child Abuse Prevention and Treatment and Adoption Reform Act, 1978 the Indian Child Welfare Act, 1980, 1980 Adoption Assistance and Child Welfare Act, 1988 Child Abuse Prevention, Adoption and Family Services Act, and finally we get to the, I call it the Big Megillah, the 1997 Adoption and Safe Families Act, which set time frames for the achievement of permanency. A lot of those time frames is to be monitored by the court, and the court was established as the gatekeeper for these cases. 1999, we have the Foster Care Independence Act. 2006, Safe and Timely Interstate Placement of Foster Children. 2008, Fostering Connections, designed to assist foster youth as they transition to adulthood. And 2015, Justice for Victims of Trafficking. 2018, this year, we have also the Family First Prevention Services Act, which we will discuss a little bit later in this presentation. So we have a long history of federal laws designed to protect children and move them expeditiously and safely through the child welfare treatment when there are allegations or proof of maltreatment. So we are still in the situation, though, where there are more children from racial and ethnic groups in care than they are represented in our society. So what is going on here? We need to figure out how to, as I said earlier, not create situations where we are just doing cookie-cutter responses to maltreatment. So every parent does not need to get a GED. Every parent does not need to necessarily complete a job training program. The family must be, the child must be, the parents must be examined where they stand. So once we have applied the law in these circumstances, we have to examine and understand our own assumptions and perceptions of children and their families who are a part of the intervention process in our society. We also have to understand that they come from communities that have strength, and that those communities can be relied on to assist in the rehabilitation effort. We also have to examine and let those assumptions and perceptions give way to a methodical approach to questioning the reality of the lives of children and families who find themselves involved in the system or before the court. So how do we do this? We need to create a balance between cultural and family context and the compliance with the law. And that begins with repeating again the following principles. Each family is unique. Each family is different in key aspects of each family member's life. Services to families must meet the specific needs of each child and each family member. Going on to talk a bit more about the context of family, the solutions that the system attempts to help the family members and the children with need to successfully move toward permanency and the end of the child welfare system involvement in a family's life. And that must be based on a clear and careful examination of that family uniqueness, the family differences, the family needs. Families also must have a voice, and we often have failed to listen to or hear the voices of family members, including the children, because they create the context that then we can help figure out what services might be necessary to create a safe and a resilient environment for children and families. Now, family context and cultural context provides the backdrop upon which judges, attorneys, social workers, law enforcement, and other service providers, including domestic violence advocates and batterer intervention programs where domestic violence is an issue in a case. This context can determine the levels and types of interventions, if any, needed by each child and each family member. Have any of you thought about the times that in your work children have been removed, court cases opened, and then within 60 days they're back home? Did we consider the context, both cultural and social, of that family before that removal occurred? Now, context also provides an opportunity to address the anticipated impact of services on the outcome of each case. Now, understanding the meaning of community diversity and what that diversity means to the lives of children and families is extremely important. But often the system is not able to really dig deep into the community, and it requires a different approach to community engagement, one that we may not have consistently done in the past. Now, we also need to look at understanding how culture and subcultural elements affect the ability of children and families to participate in their own rehabilitation process to achieve permanency and ensure that short-term intervention does not turn into an opportunity for disparity between children from different backgrounds. Now let's take a look at an example. James is a 5-year-old African-American boy. He's one of 3 children. His mother allegedly, quote, beat him with a belt, leaving marks on his back and legs. The child was removed and placed in the home of an unrelated foster parent in a rural community about 50 miles from his home. This is a reality. It could be a Hispanic child. It could be a Native American child. It could also be a white child. But for these purposes, we have a few elements here that become problematic. Anybody want to suggest what some of those elements are in the chat box? So here are a few more facts. At the initial hearing, the mother is present. Her attorney talks with her about the case. The case is called. The guardian ad litem appointed to represent the best interests of the child has not met with the child. However, the maternal grandmother tells the guardian ad litem that the 5-year-old has physical and emotional issues. The grandmother, who is disabled, is unable to care for the child. The other children in that family are also removed. The case plan: once the mother is drug-free, the child will be returned home. She also must secure her GED. Mom did not tell anyone that she was abused the day before the incident happened with her son by her live-in boyfriend. That changes some dynamics, doesn't it? We have a number of issues here that speak to the child, the grandmother, the family dynamic, and the family context. It speaks to the mother's dynamic, the mother's stressors. So, what do? What information is needed that could be gleaned before, during, and after the initial hearing to develop an appropriate plan for the family, assuming that the plan that was articulated in this scenario is a little bit unrealistic? Why were the other two children also removed? Was that necessary? Now, there is also additional family context, mental illness, emotional and developmental issues for both the parent and the child. What about faith? Is that an issue here? Do we know anything about the faith realities of the child, the mom, the grandmother? What about literacy? How about the ability of relatives to care for the child and options other than full-time care? And what about the distance between the placement in this foster home 50 miles from home? What does that do to the context of this family and this family's rehabilitation? All of these issues that are in this scenario are part of what leads to a longer time in care than is necessary to rehabilitate, provide services, and strengthen the family. So here are some other questions that would have to be asked, whether it's by the guardian ad litem, parents' council, the court, the social workers. What's the child's relationship with the maternal grandmother? Does she wish to be involved in his life? And how would that be accomplished? Does the child participate in worship services? We talked about that a little bit earlier. How important is that participation to the child? How important is that participation to his family? Are the faith affiliations of the foster parents compatible with the affiliation that the child is accustomed to? Are there issues related to urban versus rural environments? Key: how will visitation occur when the child is placed 50 miles away from home? How will the child receive services to address any of his special needs, as described by the grandmother and possibly documented through evaluation? And what about the domestic violence assertions made by the mom? And what role did the domestic violence have in the ultimate act that led to the teacher recognizing bruising on the child? I think you can see that by raising the questions, we increase the ability to predict and resolve issues the family may face as the reunification effort progresses, or as that effort fails. What we want to do is not be part of the failure, because we have set up realistic requirements for the mom, or maybe even for the child, or maybe even for the grandmother. Now, by raising questions early in the case, the likelihood is lessened that issues will arise to divert attention from the family's rebuilding on stronger footing to achieve permanency. Here's another example. Recently, Maria told the judge that she does not want to stay in the foster home because they do not allow the children to speak Spanish. Maria and her siblings are Spanish speakers. Maria does not want to leave her siblings, but she is finding this foster home dynamic around her native language intolerable. Now, the plan for Maria and her siblings is to be adopted by these foster parents, and they are prepared to file a petition immediately. The children have been in the home for 24 months. So let's go through the questioning. What can be done to resolve the issues presented for Maria and her siblings? Do you all have any ideas? Should there be a search for a placement that will respect the language and culture of all three children? And how do you balance that against the fact that they have been in this home for 24 months? Maria may not be as invested with these foster parents, but what about her siblings who are younger? Now, what about Maria, who is 14 and doesn't want to remain in the home? What can be done? Are there creative ways to deal with the situation that would not cast apart Maria from her siblings over time? Again, I have no answers, but these are the kinds of questions that should be asked up front. What could have been resolved with Maria if this foster home had been told that language was an important part of these children's lives, and maybe they weren't going to then be the appropriate placement? But it's the questioning that is important. Now, as the pre-adoptive family in Maria's case, do they have the capacity to view the children's culture and language with respect and allow the children to continue to participate actively in that culture for the long haul? How can that be addressed? Who's responsible for addressing it? Now, we may have to say that it may be too late to rectify the situation for Maria, but what about the other two girls? What is the best permanency option for Maria and her siblings? What do you need to know to provide assistance to the court on that issue? Now, I'm not giving any answers because every family is unique, every child is unique, but you can see where this questioning process is designed to take us. So we are not just walking down a road where permanency is delayed for children who happen to be from communities that are not the majority community. Now, has the situation with Maria and her current foster parents affected the child's interest in pursuing adoption as a goal? So what has happened before may end up affecting the child's ability to agree to what is recommended for the long haul for her. Is a decision about keeping these children together a matter of cultural and family context, or simply a matter of placement? And I think you all know the answer is this is not about placement. It really is about family and cultural context. We've talked a little bit about the harm to the younger children, particularly if they're split up. And then what impact does this dynamic and this foster home have to the ultimate overall development of each of the children, who each are unique? Now, Catherine is another example, is a 15-year-old. She's been in foster care since she was 10. She has been involved in 2 failed attempts to reunify with her birth mother and has decided she does not wish to live with her mother. Catherine's family, maternal and paternal, are very religious. Over the past 18 months, she was placed successfully with her maternal grandmother, and a paternal aunt. Each relative asked for Catherine's removal because of the friends she associates with and her mode of dress. Catherine says she identifies as a lesbian, though she states she has never had a relationship with anyone. She is seriously depressed and has tested that she requires special education services, and that's based on her IQ. The agency has identified a foster home, but Catherine is not interested in placement in a family setting. So we begin the questioning again. Can the social worker and the court ensure that Catherine is placed in a safe environment, because safety is an issue for her, where she is able to grow into herself without feeling she is not a healthy person? What discussions will the worker have with Catherine to determine whether she will agree to a foster home placement and under what circumstances? Again, we're talking about giving this young lady some voice and not just having her react to circumstances that really are beyond her control. What role does faith play in Catherine's life? We have nothing in this scenario that says how engaged Catherine has been in her faith community, if she has one. Now, is there also a faith organization that will be accepting of Catherine where she can continue to maintain a faith connection despite past rejection? And might that same community be a place where she could find comfortable placement in a family-like setting? Has anyone explored identifying a specialized placement for Catherine with a foster parent who has been trained in working with adolescents like Catherine? Has anyone explored whether a safe group setting can be identified that does not leave Catherine vulnerable to attack because of her dress and her friends and associates? And where does her intellectual functioning factor into all of this exploration, questioning, and engagement with Catherine? Is it a factor that should be considered? So, where do we go for the future? To address the consistent issues of disproportionality and disparity, as we could see with the landmines from these three scenarios, that you can imagine these children may end up, rather than having their situation and their permanency resolved within 12 months, they could end up continuing in care even through emancipation because of the missteps and the lack of exploration of family and cultural context. What we know is that all professionals involved in these cases should look for ways to identify the cultural and subcultural issues in these cases. And it's not just about the color of a person's skin or where their families of origin are from. It is complex, as Robert Hill said in that first quote. Solving these decades-old issues must involve an examination of cultural and subcultural context of each child and each family. They are going to be different for each child and each family. So we have to now look to ensuring that realistic case plans are developed at key decision-making points with the involvement and participation of children, parents, other persons that the family considers a part of the extended family, or their key members of their community as the family and the child define it. Could be a teacher, could be a coach, could be from the faith-based community. So I ask that you all consider these scenarios again. What might have been different if engagement had been different? Would it have shortened anyone's time in care? Remember Maria's situation where the foster family did not allow the children to speak Spanish. They had been in that home for 24 months. That's 2 years. Someone should have known beforehand that this might be an issue, and that would have changed the trajectory of their move through the system. Now, frequently it is the failure to identify family and cultural context that delays or derails permanency. Again, I point you to Maria and her siblings. We cannot continue to have cookie-cutter solutions. One size does not fit all. Now, to make differences work for children and families as we move forward, we We have to constantly address issues that may affect the well-being of the child before removal and consistently after placement in care throughout the life of the case. People change, things change, and the examination has to continue on a consistent basis. Now, let's talk about the possibilities of the Family First Prevention Services Act that passed in 2018. State agencies now must provide and document that prevention services were provided to the family before the case before the child will be removed from the home. These prevention services shift Title IV dollars to prevention rather than foster care. The services can last from 12 to 15 months, and if the child goes home and there is a need for another removal, prevention services are to be provided again. It's a complex act. There are lots of other factors. We will not have time to go through all of that today, but the bottom line is this is a shift and a shift that may have a positive effect on disparity and disproportionality, as you all can imagine. Now, under Family First, there are a few other components. Pregnant teens in care must receive prevention services so that the infant of the teen does not have to enter foster care. The court has to ensure detailed affidavits are provided once a case is filed, showing active and reasonable efforts to prevent the case from coming to court. States must move children from congregate care unless there is documentation of specialized needs of the child for services. And finally, there is a great deal of focus on the engagement of the family in the planning, prevention processes, and the move toward the child coming home if removal is required. The other look to the future is learning community resources that may assist with meeting the case plan. Churches, social organizations, fraternities and sororities in some communities. You know, there are communities that have had problems maintaining visitation centers during the period where reunification is attempted. There are some communities that the courts have reached out and social service agencies have reached out to faith-based community organizations to see whether that element of the community might help with a need to provide resources to children. Now, some communities have also developed programs where community members help children and families navigate the system. They may be former parents who had to engage in services with the Child Welfare Agency. They also may be community navigators who really work with the family to cut the stress of system engagement. So I'm going to ask you all again if you would put in the chat box who you might consider as community partners in your community. All right, so who are we looking toward for the future? We're looking to the tribes, local places of worship, parents who have experienced the child welfare system and are willing to give back to others who may be engaged, of course, family members. Can you imagine any other folks who should be added to this list? We have some comments that victim services organizations, schools, engaging the schools, early childhood educators, housing authorities, interesting. And again, there are also child abuse prevention programs in many communities that may have a deep reach into the community to assist in this effort. Now, for the future, we also suggest that there be an examination of the intersection of race, ethnicity, with poverty, mental health, substance use, intellectual challenges, and other social factors, including violence within our communities. Do these elements help drive change and intervention? And are we beginning to look at the intersection here of all of these social and community factors and family factors as shifting the conversation so that we're also talking about public health and not just family dysfunction? Also ask that you consider, should the discussion of overrepresentation and underrepresentation be reframed as that public health issue to ensure a truly integrated approach to child family safety, well-being, resiliency, and permanency. Our goal is for the system to be out of the lives of these families, and that can only be done when there is a focus on safety, well-being, resiliency, and permanency. Finally, there's a lot of discussion about data collection. We know that issues of disproportionality and disparity are part of what the AFCARs from Department of Health and Human Services collect from the states. But that data is on a national basis. Researchers now are talking about drilling down and beginning to collect data on these cases, not just on disproportionality and disparity, but the kinds of cases that are coming to child welfare, and that data collection be at the county level, at the city level, and maybe even drill down to zip codes. Because the patterns of needs of families and children within community segments may be helpful in resolving not only disproportionality and disparity, but assist in application of the Family First Act that just passed in 2018. Localized data collection, even at the zip code level, can help match community trends and needs with the continued reality of overrepresentation and underrepresentation, while providing opportunities to discover community resources that may assist with prevention and shorten times to permanency. As Robert Hill said in 2011, a research agenda is needed that is reflective of all people of color, sensitive to the resilience of low-income families, multi-level, multi-method, and with rigorous analytic techniques. So now I'd like to ask if you all have any questions that we could attempt to answer. We have a comment here that we need to look at ACEs in building resiliency factors. The more moves, separation from family, church, school contribute to the trauma already experienced. And this point is well taken because that trauma continues to replicate itself in one form or another. It is definitely a health issue, this participant states. There are a number of you who have commented about ACEs, and that's the early childhood trauma scale that really has been a great part of the conversation around many issues in child welfare, and assume that part of this approach about the context of the family, particularly when we're talking about children exposed to DV, even though that may not be the reason that they're coming before the child welfare agency, ACEs is part of that context of family, not because it is there, but everyone has had something happen to them. And if we don't know, we then keep stumbling and creating problems for children and their parents. Any questions, anyone? All right, there's a participant who asked the question, is there any advice on how to best achieve a change of approach by judges? Here at the council, we do make, in all of our trainings, an effort to try to talk with judges, have judges examine the cultural impact of families and their ability to get through the system, whether it's DV or child welfare. We will continue to do that. That is one of our focuses. But I would say I don't know who this participant, what professionally that person does, but I think if all of us were on the same page to basically do this individualized approach, look at ACEs, look at history, drill down into who is the family, what are their strengths, not just their weaknesses, and engage them, that will change what the judges will see when you do end up before them in court. There's a comment here, there's such a large intersection between child abuse and domestic violence, and those systems are still largely siloed. Any recommendations or promising practices that you're aware of to bridge that gap? There are a number of federally funded programs in pilot stage, demonstration stage, that are looking at the intersection of DV and child abuse and neglect. Including there are a number of jurisdictions that have begun co-locating victims advocates within the child welfare agency to begin to assist social workers in identifying the impact of domestic violence on children and families, but also including batterers intervention programs in that dynamic, because there generally is more than one parent, and the child very well may be connected to both. So it's siloed, but I think there is evidence that things are moving in a less siloed direction. So keep your eyes open for that because it will make a big difference in terms of disproportionality and disparity. Someone is suggesting that, and actually this is a great point, and I appreciate you bringing it up, that early childhood courts, the 0 to 3 courts, as well as family treatment courts, have helped to move forward the pace of reunification, or at least the pace of knowing that it's not going to happen. One of the things with the Family First Act that I would suggest that you check out is the time frames for permanency get shifted because of this focus on prevention before removal. And I think it'll be interesting to watch that process as practice and as practice develops over the next couple years. We have a comment from CASA here, and we thank you for your service, but the comment is the cookie cutter approach and a checklist for each family that's the same for each family. I think you're getting it. That is what does not work, and it keeps kids and families engaged with the system because it takes so long to then identify what really does this family need. That should be upfront. It should be upfront, and they have to be involved in the definite in defining what it is that they need. I don't see any more comments or questions. I hope that we were able to answer We have comments from some tribal participants who indicate that there are community organizations, including domestic violence programs and the Indian Child Welfare Representative, that needs to be engaged in the conversation. We also suggest to judges, there was a question about what can judges do. We really encourage judges to get out front and lead on this issue, particularly if we can see that there are issues with children remaining too long in care because there were missteps early on in the process. Another participant points out an error on slide 14. We'll try to make sure that that gets corrected. I think you're right. I stumbled over those numbers and I said, oh, something's wrong here. So thank you very much. All right, any other comments, questions, suggestions?
A couple of people are typing, and so I just want to make one quick note to you about the updated slides. We will correct those numbers, and we'll send out an updated handout to everyone following the webinar.
All right, we have a comment question here. How are the intersection of LGBTQ and child abuse and DV being addressed? Will we receive a URL to the recording of this presentation? I think the question about how the intersection of LGBTQ and child abuse and DV are being addressed, and I actually can say that addressing it is the same as addressing any other issues about the context of the child and the family. We have not necessarily engaged in that, but that's part of what our future discussion should be. We do know that a number of aging out children from foster care end up homeless. A number of those children are LGBTQ. There aren't the kinds of services available in every community to meet the needs of children who are in that cultural group. There's a question, is there a good resource on early childhood courts? I would suggest that you go online and look at the 0 to 3 program. You should get a number of sites that you could explore. It may not be about the courts, but at least you would have some sense of what's being done in various communities. You could also put in early childhood courts or 0 to 3 courts, and you'll see some of the work that's being done across the country. We have a question here. How are you helping those teens get permanently housed that are becoming homeless when they age out of the system? One of the things that through the Chafee Act and extended through the 2018 Family First Act, the age of support for teens who are in the process of transitioning to adulthood is slowly being extended. So services such as training and other housing voucher programs, there's room for assisting the kids for a longer period of time. I would refer you to the Act. We don't have time to go through all of the various provisions, but there appears to be a federal awareness, and I know there's, in many communities, there's an awareness of this being a population that we need to really stick with and help move them healthily into adulthood. All right, I don't see any more chat.
It looks like there is a couple of people still typing, and so while they're typing, just some housekeeping things for participants. Once we close out today, you'll be directed to an evaluation link. Please fill that out. Let us know how we did today. And you will also, that is also the link that you will go to request a certificate of attendance. So if you would like to have a certificate for today's event, they are available. Just go to the link and request it there. The webinar is also being recorded. We will post it online on our Resource Center website, and we will be sending that link to everyone who attended today, as well as all registrants. So if you have any colleagues who missed it, they will be able to view it afterwards.
All right, one of the participants indicates that you may want to look at the Federal Head Start, which actually is the source of the 0 to 3. They may also be a resource for childhood courts. We still have people typing.
thank you so much. We're at the top of the hour. If you have any further questions, feel free to email the presenter. Her email is right on the screen. And don't forget to go to the evaluation link for any certificates or follow-up questions. Thank you so much.